This case has impacted everyone's day-to-day as a family lawyer. It has got them really thinking about how they construct their case.
Hi everyone, I'm Yogesh Patel, General Manager of Family and Estates at InfoTrack.
And I'm Bree Staines, the family lawyer here at InfoTrack.
We know that you get a variety of updates and information about any legislative or case law updates to family law from a variety of sources, often in real time. And you know what? We're not here to change that. But we think, as family lawyers that use technology, hopefully InfoTrack, that you expect your technology to stay up to date with any of those changes. So what we wanted to do today was talk about a recent decision and how that might impact the technology that you use or ought to use going forward. So Bree, a recent decision of the full court that people are calling seminal, I think I've read. What is that decision?
So that decision is Shinohara.
Talk to me about the facts of the case, I guess at the initial decision.
Yeah, so Shinohara was a case about property and parenting matters. So it was a property pool of about $600,000 of net assets, which is quite small, plus superannuation, but the parties dealt with that separately. So the $600,000 was ultimately split 50-50 between the husband and the wife. On contributions, the wife received 60% because the court recognised that she had greater financial contributions during the relationship compared to the husband. But then the court did a 10% adjustment to the husband on his future needs on account of care of the children.
I understand the wife appealed. Why was that?
So the wife appealed on the basis of procedural fairness. So the parties agreed in the first instance judgment to fill a balance sheet that included addbacks from both the wife's side and the husband's side. So they both had spent money, basically, and they both wanted that added back in. What the trial judge did is actually ignored those addbacks, but didn't actually give, in the wife's case, her procedural fairness to make an argument as to how those addbacks could otherwise be accounted for in the decision if they weren't included in the balance sheet.
And spoiler alert, something big happened between the initial case and the case being reheard on appeal. Is that right?
That's right. The big legislative change of the 10th of June, which I'm sure everybody knows about.
Okay, but specifically when it comes in relation to this particular case, how did the legislative change be dealt with by the full court?
So the specific section is section 79, subsection 3,
Yep.
which basically says that the court can only divide existing assets of the parties. So addbacks by their nature is a notional property that doesn't exist anymore. So the full court made it very clear that you can't have addbacks in your balance sheet, whether you agree or not, because that property doesn't exist. So the court can't do anything with it.
Okay, so what does that mean for the husband and wife, or the ex-husband and wife in this particular case?
So you really need to restructure how you argue your case, and that was the basis of the wife's appeal and how the full court decided the matter when they re-exercised their jurisdiction. So basically, you need to look at how the contributions element, so how the property was dissipated, could be argued on contributions basis, and then also what effect the dissipated property has on each party's future needs, so their future circumstances, and that might lead to an adjustment on that basis.
Well, Bree, you've been with us for over 6 months now, and during that time, I guess you had a big say and a very influential say in how we develop and tweak our family law product and what's coming next. With the products that we have at the moment, do you see any of them being useful for family lawyers who want to make sure they don't fall awry of the legislative change? How do you think that legislative change might impact their sort of day-to-day and the technology that they use?
This case has impacted everyone's day-to-day as a family lawyer. It has got them really thinking about how they construct their case. And I think our technology really assists with that in the circumstances of our searches and our financial disclosure product.
Okay, well, why don't we talk about searches and financial disclosure? When you say searches, what do you mean specifically?
So primarily you'd be looking at your ASIC searches and your title searches.
Okay.
But we obviously have a host of searches at InfoTrack, and the idea of searches is to really identify the property interest and identify legal ownership. So that's your first step to determining what still exists or what might not exist anymore, but your client might be saying, we did have this property, but now my husband doesn't own it anymore. You were able to obtain that information and get that evidence from searches.
You mentioned financial disclosure, which is a product I really love, and we've had great feedback from family lawyers. For those who haven't used our financial disclosure product, what is it?
So really, it's a two-part product. So you have the request that's being sent from the lawyer to the client to obtain their financial documents and material. And it provides your client a really systematic way to upload the material. And there's categorization, so you're giving them information and assistance as they do that. Then on the flip side, it provides the lawyer a very organized way to receive the material rather than
dribs and drabs, right?
Rather than dribs and drabs, and provides an organized fashion for them to be able to go through all of that material and start to understand what is in the property for.
Okay, and then I think specifically what I'd want to know is, with this recent decision and the changes in how Addbacks are being thought about, particularly with the legislative requirements, how do you see a tool like financial disclosure helping?
So it allows your client to provide you more evidence as the lawyer. So you want documents, and you want as many documents as possible to be able to explain the story of any change in property during the course of the relationship or post-separation. You can't just rely on your client's instructions. You need documentary evidence to support that. Financial disclosure allows a place for your client to easily understand that and to be able to easily provide you those documents.
So we talked about how financial disclosure can help lawyers in particular with the recent legislative changes and the interpretation by the full court. What do you think is next for family lawyers and how they can use technology to sort of stay abreast of any legislative changes?
I think the key there is, as you said, using technology, because as I mentioned, there's so many potential for so many more documents and so much more evidence to be needing to be put forward to the court, and such a broader range of instructions that you're obtaining from your client. So that's just generally a lot more work to do in a day-to-day, and you want to lean on technology to be able to help you with that work and use it to your advantage, whether it's from admin or whether it's to help you understand the case law, or just basically getting your day done quicker and more efficiently for your client.
So I think lawyers can effectively use technology as the legislation starts to be interpreted a little bit more. And when that interpretation starts to take place, they should be leaning in on their technology providers to make sure they're providing solutions that can actually make their lives easier, save them time, and I guess essentially spend more time with their clients rather than spending more time on things like admin.
Exactly, especially in family law when you need to be with your client.
Well, we're really excited to have you here to help us on that journey, and really looking forward to what we come up with next.
I am too. Thank you.